In the summer of 2024, the highest court in America delivered a ruling that constitutional scholars are still debating, that legal experts are still analyzing, and that every American needs to understand. A 6-3 majority on the Supreme Court decided that former presidents can claim criminal immunity for actions they take while in office, setting a precedent that did not exist in the entire 230-plus-year history of the Republic. That single decision, handed down on July 1st, transformed how we think about presidential power, about accountability, and about the future of American democracy itself. But this was not the only Supreme Court case involving Donald Trump that year. There was another unanimous ruling just months earlier that addressed whether he could even appear on a presidential ballot. Together, these two decisions tell a story about the courts, about constitutional interpretation, and about the tension between institutional integrity and political reality. If you have been watching these developments unfold and wondering what they actually mean for the country, you are in exactly the right place. This is a story about power and its limits, about law and its interpretation, and about the questions that will define American governance for generations to come. The first major case we need to understand is Trump versus the United States, the presidential immunity decision that dominated legal headlines throughout the first half of 2024. This case arose from the federal criminal indictment filed against Donald Trump in August of 2023, the one that charged him with 4 counts related to his actions following the 2020 presidential election. Special counsel Jack Smith alleged that Trump had engaged in a conspiracy to defraud the United States, a conspiracy to obstruct an official proceeding, and other related charges stemming from what the government described as an effort to overturn the legitimate results of the 2020 election. Trump's legal team argued that a former president cannot be prosecuted for actions taken while serving in office, that criminal prosecution would unconstitutionally intrude on executive power, and that the separation of powers demanded absolute immunity for a sitting president's official acts. The case moved through the federal courts with unusual speed, and by February of 2024, the Supreme Court agreed to take it up on an expedited basis. The court's decision, written by Chief Justice John Roberts, divided the country along ideological lines. Roberts wrote that a former president does have criminal immunity for his core constitutional powers, that absolute immunity must attach to actions taken within the conclusive and preclusive authority of the presidency. He drew a distinction between official acts and unofficial acts, holding that while the president has no immunity for unofficial conduct, he is entitled to at least presumptive immunity for actions that fall within the outer perimeter of his official responsibility. The majority reasoned that requiring a president to face criminal prosecution for official actions would dangerously intrude on executive power, would create distracted presidents constantly worried about legal exposure, and would undermine the energetic executive that the founders designed. Roberts sent the case back to the lower court with instructions to sort out which of Trump's alleged actions were official and which were unofficial, a task that legal observers immediately recognized would be extraordinarily difficult. The dissenting justices offered a fundamentally different vision of constitutional accountability. Justice Sonia Sotomayor wrote that the decision makes a mockery of the principle that no man is above the law, that the Constitution does not shield a former president from answering for criminal acts. She warned that never in the history of the Republic has a president had reason to believe he would be immune from criminal prosecution if he used the trappings of his office to violate the criminal law, but that moving forward all former presidents would be cloaked in such immunity. Justice Ketanji Brown Jackson agreed fully with Sotomayor's analysis and added her own concerns about the new presidential accountability model the majority had created. She noted that under this new framework, the starting presumption is that criminal law does not apply to presidents no matter how obviously illegal, harmful, or unacceptable their official behavior might be. Jackson expressed fear that her colleagues had put their trust in the court's ability to prevent presidents from becoming kings through case-by-case application of indeterminate standards, and she openly wondered whether that trust was misplaced. The political and legal implications of this decision are still rippling through the system. When the Supreme Court sent the immunity question back to the district court, it effectively delayed any trial until after the November 2024 elections. Prosecutors now must prove not only that Trump committed the alleged crimes, but also that those crimes were unofficial acts not covered by immunity. They cannot use evidence of Trump's conversations with Justice Department officials, a significant portion of their case. They must navigate a maze of legal distinctions between official and unofficial conduct while a presidential election unfolds. Legal experts across the political spectrum have noted that the court's decision creates perverse incentives, that it arguably invites future presidents to use the machinery of government to commit crimes as long as they can characterize those crimes as official acts. This is not merely theoretical speculation. This is the logical consequence of the framework the majority adopted. We can see the immediate practical effect by looking at the other major Trump case from 2024, the one involving ballot eligibility. In Trump versus Anderson, the court addressed whether Colorado could remove Donald Trump from its presidential primary ballot under Section 3 of the 14th Amendment. That provision, ratified after the Civil War, bars from office anyone who took an oath to support the Constitution and then engaged in insurrection or rebellion against it. A group of Colorado voters argued that Trump's actions surrounding the January 6, 2021 attack on the Capitol constituted insurrection, and that he was therefore disqualified from the ballot under this rarely invoked constitutional provision. The Colorado Supreme Court agreed with the voters, but the U.S. Supreme Court unanimously reversed that decision in March of 2024. The court's unanimous ruling was notable precisely because it was unanimous. Even the justices who had most strongly defended Trump's interests in other cases joined an opinion that restored him to the Colorado ballot. But the unanimity conceals significant disagreement about why the court reached this conclusion. Chief Justice Roberts wrote that the Constitution makes Congress, rather than the states, responsible for enforcing Section 3 against federal office holders and candidates. The majority reasoned that the 14th Amendment expanded federal power at the expense of the states and that only Congress can determine how to implement the disqualification provision. States can regulate state-level elections but cannot unilaterally decide whether a candidate is disqualified from the presidency. Roberts famously worried during oral argument about the consequences of allowing states to make this determination, noting that it would effectively allow a handful of states to decide presidential elections by booting candidates from ballots. The three liberal-leaning justices wrote separately to criticize the majority for deciding momentous and difficult issues unnecessarily, and for creating what they called a special rule for the insurrection disability that went beyond what the case required. Justice Amy Coney Barrett, appointed by Trump, also wrote separately to say the court did not need to address the complicated question of whether federal legislation was the exclusive vehicle for enforcing the 14th Amendment. Her tone was notably restrained, suggesting that the court should turn the national temperature down rather than up during a volatile presidential election season. These separate writings reveal a court that, while agreeing on the outcome, was deeply divided about the constitutional reasoning that led to that outcome. One critical point that emerged from the ballot case is that the Supreme Court did not rule on whether Trump's actions constituted an insurrection. The court accepted the premise that January 6 was a riot and that Trump had played a role in the events surrounding it, but it declined to decide whether that conduct rose to the level of disqualifying insurrection. The court simply said that even if it did, states cannot enforce the disqualification, only Congress can. This left the underlying factual question unresolved and created a peculiar situation where Trump could be restored to the ballot without anyone officially concluding that he had not engaged in insurrectionist conduct. Critics of the decision argued that the court effectively gave constitutional immunity to insurrectionists by creating an enforcement gap that Congress has not yet filled. The intersection of these two cases tells a powerful story about the Supreme Court's current orientation. On the one hand, the court unanimously kept Trump on the ballot by limiting the ways that states can enforce constitutional disqualification. On the other hand, the court gave Trump a significant legal shield against criminal prosecution by recognizing broad immunity for official acts. These rulings taken together create a situation where a former president can run for office while potentially being immune from criminal accountability for actions taken while president. This is not a scenario the founders anticipated, and it raises fundamental questions about what accountability means in a democratic republic. Constitutional scholars have noted the unusual nature of the immunity ruling. For over 2 centuries, American law operated on the assumption that no one, including the president, was above the law. The Clinton versus Jones decision in 1997 had already established that sitting presidents could be subject to civil lawsuits for conduct unrelated to their official duties. but criminal immunity for official acts had never been definitively settled. The Supreme Court's decision in Trump versus the United States settled that question in a way that created entirely new constitutional territory. The majority drew on civil immunity precedents from earlier cases involving executive officials, but the application to criminal prosecution of a former president was novel. Critics argue this is precisely why the decision is so dangerous, because it was not grounded in established precedent, but rather extended civil immunity doctrine into criminal law in ways that prior courts had explicitly avoided. The practical effect of the immunity ruling on the January 6th case has been substantial. Federal prosecutors were forced to abandon their initial legal theory about Trump's conversations with Justice Department officials, conceding that those conversations involved official acts that are now, at least presumptively, immune. The prosecution must proceed with the theory that Trump's actions were unofficial, but the legal standard for making that distinction is now more favorable to the defense than it was before the Supreme Court weighed in. Judges applying the new standard must not inquire into the president's motives, must not classify an action as unofficial simply because it allegedly violates a generally applicable law, and must give presumptive weight to the characterization of conduct as official. These constraints significantly complicate the prosecution's task and almost certainly extend the timeline for resolution. The timing of these rulings has political significance that cannot be ignored. By the time the Supreme Court issued its immunity decision in July of 2024, the case had been structured so that any trial would not conclude before the presidential election. The court declined to hear the case on a timeline that would have allowed resolution before the election season accelerated. This meant that voters went to the polls without knowing whether Trump would face criminal accountability for his actions, without knowing whether the January 6th case would proceed, and without the resolution that many observers had hoped the courts would provide. Whether this timing was deliberate, incidental, or simply the natural consequence of a rushed docket is impossible to determine, but its effect was to insulate the political implications of the ruling from immediate electoral judgment. Historical context helps us understand why these cases are so consequential. The concept of presidential immunity has never been definitively resolved in American law, in part because the founders disagreed about it, and in part because no prior president had been indicted for actions taken in office. Thomas Jefferson, when facing potential prosecution for his actions as president, argued that immunity was necessary for effective governance. John Marshall, in a famous opinion about executive officials, suggested that some immunity was appropriate. But the specific question of whether a former president could face criminal prosecution for official acts remained genuinely unsettled until the 2024 ruling. The court, in resolving this question, created new law rather than simply applying established precedent, and the new law it created is controversial, contested, and potentially transformative. The broader implications for democratic governance are profound. If presidents have broad immunity for official acts, they have less reason to avoid using the powers of their office in questionable ways. If they can characterize potentially criminal conduct as official, they face reduced accountability. If the only check on presidential misconduct is impeachment, and if impeachment is a political rather than legal process, then the practical limits on presidential power shift dramatically. Critics of the immunity ruling argue that it effectively licenses future presidents to engage in conduct that would previously have been prosecutable, that it creates a class of individuals who are functionally above the law when acting in their official capacity. Supporters argue that it protects the independence of the executive branch, prevents frivolous prosecutions designed to harass presidents, and ensures that chief executives can perform their constitutional duties without constant fear of criminal exposure. The ballot eligibility case raises separate but equally important questions about federalism and constitutional enforcement. The 14th Amendment was designed to prevent Confederates from returning to power after the Civil War, and it established a national standard for disqualification that states were not permitted to apply unilaterally. The court's interpretation of this provision as requiring congressional action to implement created an enforcement gap that has never been filled. Some legal scholars argue that the gap is intentional, that the founders of the 14th Amendment wanted Congress to have the power to decide when and how to enforce disqualification. Others argue that the provision is self-executing, that it operates automatically without congressional action. The Supreme Court resolved this question in favor of the congressional enforcement view, meaning that unless and until Congress passes implementing legislation, the disqualification provision may be unenforceable. The political consequences of these decisions will play out over years and decades. Every future president now operates under the cloud of the immunity ruling, knowing that their official actions may be treated as presumptively immune from criminal prosecution. Every future candidate now knows that the Supreme Court will not allow states to unilaterally disqualify them from the ballot based on constitutional provisions that Congress has not implemented. These rulings reshape the landscape of presidential power in ways that will be debated, analyzed, and litigated for generations. The questions they raise about accountability, about the rule of law, about the limits of executive power are not going away. They are, if anything, becoming more central to American political life. As we consider the implications of these cases, we should remember that they arise from specific facts about specific events. The immunity case arises from allegations about Trump's efforts to overturn the 2020 election. The ballot case arises from the January 6th attack on the Capitol. Whatever we think about the legal rulings, we should be clear about the underlying events. Multiple courts have found that these events occurred, that there was an attack on the Capitol, that Trump's actions contributed to it, and that there are serious questions about whether those actions were lawful. The legal rulings determine how those events are processed through the criminal justice system and through election law, but they do not change what happened. Understanding what happened and why it matters is the essential first step to understanding why these cases are so consequential. The Supreme Court in both cases demonstrated a particular view of constitutional interpretation. In the immunity case, the majority prioritized the functioning of the executive branch over individual accountability, a perspective that critics see as fundamentally misreading the constitutional design. In the ballot case, the majority prioritized national uniformity over state enforcement, a perspective that critics see as reading the 14th Amendment too narrowly. In both cases, the court's conservatives found ways to rule in Trump's favor, sometimes unanimously, and sometimes by the narrow 6-3 margin that has characterized the court's most controversial decisions. The ideological pattern is difficult to ignore, even as the legal reasoning tries to obscure it. What does this mean for the average American? It means that the rules governing presidential power are changing, that the accountability mechanisms that citizens rely on to check executive abuse are under stress, and that the institutions responsible for resolving these questions are themselves part of the political conflict. It means that elections matter more than ever because the people we choose for president will now operate under different legal constraints than their predecessors. It means that Congress has a role to play in clarifying these questions, but that Congress is itself deeply divided and may not be able to act. It means that the judiciary will continue to be central to American politics, and that who gets appointed to federal courts will continue to be one of the most consequential political questions of our time. The story of Trump versus the United States and Trump versus Anderson is ultimately a story about how constitutional democracy manages extreme situations. The founders designed a system with checks and balances, with multiple branches of government checking each other's power, with courts available to resolve disputes about the meaning of the Constitution. But the system was not designed to handle a situation where one branch claims immunity from criminal prosecution, where candidates can be removed from ballots based on disputed theories of constitutional disqualification, and where the courts themselves are polarized along political lines. The system is being stress-tested in ways that the founders did not anticipate, and the answers it produces will shape American governance for decades to come. We are living through a constitutional transformation, even if most Americans do not realize it yet. The rules that govern presidential power are being rewritten in real time through these cases, through subsequent litigation, and through the political battles that surround them. Whether you believe this transformation is positive or negative, necessary or dangerous, it is happening. Understanding what is happening, why it is happening, and what it means for the future of democratic accountability is not optional for engaged citizens. It is essential. The Supreme Court has made its decisions, but the conversation about what those decisions mean, about whether they were right, and about what should be done about them is just beginning. That conversation will define the next chapter of American constitutional history, and every American has a stake in its outcome. Thank you for staying with me through this analysis. These are complex issues that deserve careful attention, and I appreciate that you have given it. If you found this discussion valuable, consider sharing it with others who are trying to understand what is happening in our courts and our democracy. The more people who engage seriously with these questions, the better our chances of navigating them successfully. Stay informed, stay engaged, and remember that the rule of law depends on informed citizens who care about its preservation.